Thanks, Lachlan Corla. I'd like to thank the Count Corla for picking this issue. Minister, 2 weeks ago I raised this issue with the Taoiseach at Leaders' Questions relating to the ODCE report into the mishandling of the investigation into the CEO of Anglo-Irish Bank, Sean Fitzpatrick, and his annual warehousing of personal loans from Anglo. I said that I had seen the ODCE report and that the report was a whitewash. Lachlan Corla, I wish to correct the Dáil record on this matter. It was not the original ODCE report that I had seen, but rather a government account of the investigative failures of the ODCE identified by Judge Aylmer and the steps being taken to address them. I know you've published it today, Minister. We've seen it 2 weeks ago, and I've read it twice. And Minister, I'm sad to say, but it actually is a whitewash. Minister, you said in the introduction to this document that the aim of publishing this account is to present the facts surrounding the investigative shortcomings identified by Judge Aylmer, to learn from them and to take measures to address them. I'd like to know, Minister, where in the document that does this. The document prepared by your department that I have seen certainly does not do this. Minister, the ODCE report into the collapse of the Fitzpatrick trial was requested in May 17 by the Minister for Business at the time under Section 955 of the Companies Act 2014, following a direct request by Taoiseach Enda Kenny. Section 955 requires the Director to give information to the Minister and, when requested, to account to a committee of the Oireachtas. This is a reporting requirement. You are now telling us that due to Section 956, which deals with confidential information, that you don't have the power to publish the report. I don't accept this, Minister. Section 956 does not relate to reports requested under Section 955. Section 956 deals with protecting confidential information that the Director has accumulated when performing his functions. Those functions are set out in Section 949. The power contained in 955 is not a function of the Director, but is a reporting requirement. Minister, the ODCE report is 250 pages in length. It's been on the desk of the various ministers of the Department of Business for 17 months, including yours. The Director of the ODCE himself, in the opening pages of the original report, states that no information or document has been omitted from this report on the basis that it would prejudice the performance of any of his functions. How then can the Minister refuse to publish the report when the Director of the ODCE himself has stated that nothing in it would interfere with his functions? I don't understand your argument, Minister. Minister, the way the government has dealt with this raises a lot of questions. One of the Taoiseach's key areas that he focused on when having his leadership battle with Simon Coveney was white-collar crime. He said he was going to make it a priority. But he's actually done absolutely nothing with sense. And if it's a priority, why won't you just publish the ODCE report? It doesn't make any sense at all, Minister. Minister, there are so many unanswered questions about the Fitzpatrick trial, about the ODC handling of it, on Garda Síochána involvement, the decision to pursue a second trial. Minister, maybe it might seem that I'm being cynical, but it seems like to me it suits you. You want this to go away, and you're happy to hide behind the Attorney General's advice in order not to publish it. We, as legislators, Minister, are going to be expected to sign off on a new body, a beefed-up ODCE, sometimes in the near future. How can we, as legislators, actually even consider the new legislation when we can't even see where the problems came from in the past? Do you not think, Minister, that in the interest of democracy and in the public interest, that it's absolutely crucial that the government publishes the full ODCE report and as soon as possible?
Thank you, Minister.
And I just want to thank the Deputy for raising this matter. One of the most complex and largest investigations in the history of the state commenced in 2008 with the investigation by the ODCE into Anglo-Irish Bank. The trial in this case ended when Judge Aylmer directed the acquittal of the defendant on all charges. Following Judge Aylmer's ruling of the 23rd of May 2017, the then Minister for Business, Enterprise and Innovation requested a report from the Director of Corporate Enforcement on the issues arising in the trial. This report, which the Deputy is referring to, was delivered on the 23rd of June 2017 to the then Taoiseach and Minister for Business, Enterprise and Innovation. There has been extensive engagement with the Office of the Attorney General on the publication of the report. It was hoped initially that it would be possible to publish the report, and however, prior to making it a final decision as to publication, further consideration had to be given to the confidentiality obligations on information in the possession of the Director, as there is a public interest in ensuring that ongoing and future investigations are not compromised by the disclosure of details of an individual investigation and the investigative process itself. Because of Section 956 of the Companies Act 2014, I, as Minister for Business, Enterprise and Innovation, am prohibited from publishing reports prepared pursuant to Section 955 of the Act. While it is not possible to publish the report itself, I have this afternoon published an account of the investigative shortcomings identified by Judge Aylmer. My aim in publishing this account is to set out the factors that led to these shortcomings so that we can learn from them and take measures to address them. The focus of the account is on the ODCE role in terms of the shortcomings identified and not on the other parties involved in this case. In the interest of balance, it is important, however, to emphasise that the shortcomings in this instance should not overshadow the ODCE's track record in previous investigations and prosecutions which have led to successful convictions. I completely accept that the standard of investigation in this particular case fell below appropriate standards. The judge's findings point to the need for a broader skill base, and this happened between 2008 and 2012. The judge's findings, as I said, point to the need for a broader skills base, a greater range and depth of knowledge and expertise within the office, and a greater appreciation of the necessity to employ appropriate procedures and manage risk. Now that we know the factors that led to the shortcomings, our focus has shifted to ensuring that we use the learnings from this investigation, note the steps already taken to address them, and identify further measures to enhance the capacity of the ODCE to tackle corporate wrongdoing. Since the time of this investigation, the Director of Corporate Enforcement has implemented multiple reforms within the ODCE, which addresses many of the issues that led to the investigative shortcomings outlined by Judge Aylmer. The drafting of the company's corporate enforcement bill to establish the ODC as a stand-alone agency will build on these reforms and ensure the ODCE is better equipped to investigate increasingly complex breaches of company law. Furthermore, as part of the process of preparing this bill, any further powers that are identified as a requirement for carrying out the functions of the agency will be considered as appropriate. I have secured an extra $1 million for the ODCE for 2019 to assist with its transition to a stand-alone agency.
Thank you, Minister. Deputy Wallace, 2 minutes.
Minister, all you're doing there is, first of all, your report doesn't give us the answers that we're looking for. You're defending the OCE there. I'm not actually attacking him. I actually had a meeting with him last Friday. I don't know how often you've met him, but I had a meeting with him last Friday and I actually found him an impressive individual, right? But you know what? You do him a favour by publishing his report. Not publishing it is not doing him any favours. Minister, your report does not outline any of the investigative failures or shortcomings which Aylmer identified, and I can tell you the 15 pages of Aylmer's report after he thrown out the case is a lot more informative. In fact, it's 20 times more informative than your account. Minister, your report ignores the fact that there was a deliberate attempt to actually build and construct the case rather than to investigate the case independently and impartially. At this stage, Minister, I am convinced that we need a full independent inquiry if we're going to get information, get understanding, find out where we're going. We're talking about forming a new entity, and fine, I don't have a problem with that, because we need to do something serious about tackling white-collar crime. But please, it doesn't stack up for the government to hide behind the AG's advice and not publish the ODC report. And I don't believe that you can actually continue down this road without a full independent inquiry. I find it interesting, in the House of Commons today, they've had a vote about the AG's advice. and they've just been beaten, and the AG is going to be censured in the House of Commons for refusing to actually publish his advice in relation to legal advice he got in relation to Brexit. He too was hiding behind the public interest, whereas in actual fact it's in the public interest to be transparent and open. And if we want transparency and openness around what happened since 2009, how the whole Fitzpatrick case was dealt with from the start to the finish, we need a full independent inquiry. And for starters, we need to see the ODCE's original report, 235 pages, published. Yeah, I've outlined with the different sections why even the ODCE director himself has pointed out that there is no obstacle to printing this, only your government are hiding behind it.
Minister Humphreys, 2 minutes to conclude.
Just to say, Deputy, I'm not hiding behind it. If I could publish this report, I'd quite happily do so. But if I do that, I will break the law, and I have no desire to break the law, and that is fact. That's fact. Yeah. No, that's.
terrible. Let the minister conclude. She's 2 minutes.
Can I also say that this investigation is now historic, and it's crucial to understand the factors that led to the shortcomings identified by the judge, so we can take the measures to address them. And do you know what the measures are to address them is to strengthen the ODCE, give it increased powers. This is the biggest investigation to take place between 2008 and 2012. At that time, it was one of the most complex investigations in the history of the state. And it's clear that the investigation was not up to the standard required, and the ODCE did not have the skills to take it on. In 2008, they didn't have one forensic accountant, not one. But since then, since 2012, in fairness to the current Director of Corporate Enforcement, he has upskilled, he has got further resources, he has upskilled, he has brought in expertise. He now has 8 forensic accountants, 1 digital forensic scientific specialist, 2 enforcement portfolio managers, 2 enforcement lawyers. The ODC has been put now on an independent footing. They're going to have more autonomy to get the people they need, more money, an extra $1 million for them. So I think we need to, this is going to help the ODCE to do the job it has to do. And the job it has to do is to ensure that companies so it's going to have more powers to improve search and entry powers, and to enhance its ability to gather evidence that is held electronically. Improvements in the supervision of liquidators, more simplified systems when going to the High Court to access phone records. That's in the legislation. So I want to make sure that what happened will not happen again.
Topical.